Our topic today is the fundamentals of negotiation, how to negotiate with somebody, whether it's in a transactional setting or a litigation setting. And we're going to talk about the fundamentals and talk about the fundamentals in particular to help you get ready for the Emory negotiation exercise that you're going to conduct with the Hewitt versus Gonzalez case. My name's Paul Zwier. I'm a professor and head of the litigation skills program here, and I thought it'd be helpful for you to have some notions of the skill of negotiation, and especially some of the language, because your teachers are going to refer to this language of negotiations as a way of helping you think about how best to conduct the negotiation. When you're thinking about negotiations, you need to realize that you're dropping into a very well-studied and a thought-out area, especially if you think about it as something you might study as conflict resolution, something that is community dispute resolution kinds of skills. But negotiation also can be thought of as something that is got an economic base to it. It can be studied in terms of game theory. And so it's important to realize that there's a lot of literature about negotiations. You can, as I said, talk about it from a game theory perspective, and that's in a sense what we're going to do to help us think about negotiation. We're going to conduct a game. You're going to negotiate for Hewitt versus Gonzalez, and you're going to try to figure out what's the best way you might resolve this dispute. And we played games with folks in resolving disputes, whether it's a game of battleships or whether it's the game about how to meet somebody in New York when you haven't prearranged where it is that you're going to meet. You, in a sense, get into the mind. It has to do with psychology, and we figure out what would a rational person do. We anticipate moves, and then in the playing of the games, we can draw some lessons. What's important to realize from the game theory studies is that some of negotiations, when I talk to you about it, you'll say, oh, I know that. I might not call it that, but I know how to do that, and I'm good at that. And there are other things I hope you look at and say, ooh, that's counterintuitive. I'm not sure that I buy that. And it's important to see that game theory sometimes challenges our assumptions about whether we can just go with our intuition. Now, as I said, a lot of the way of looking at dispute resolution could be thought of as a dispute about economic value of various items in dispute, and therefore economic theory, supply, and demand, whether there's an exclusive relationship that's going on between the parties that therefore allows us to think about a price that's higher, or whether or not there is high demand for a product, and because there's high demand for it, the price has to represent that. And then, of course, if we've got an oversupply, if you can get that from any place or anywhere, economic theory would tell us that the price of the good is then likely to be lower. And so economic theory informs how it is that we put values on things for the purposes of rationally trying to reach a resolution. One of the things that we can look at is to look at international politics and look at the ways that the diplomats have resolved disputes. Shoot, if you can solve a dispute in the Middle East, you ought to be able to solve a dispute between Hewitt and Gonzalez, for example. And so international politics can inform, and there are theories that have come off of international politics that are very important for us to know in order to think about how you might be able to get to yes, to overcome resistance, to reframe issues, and international politics can help. It's interesting, as you think about negotiation, to recognize that part of what informs our expectations can vary depending upon ethnicity and cultural differences that are existing in different cultures that could create expectations. If I say that I plan to meet with you tomorrow, Allah willing, it may be that I am really making a very tentative statement, whereas in the West, if I say I'll meet you tomorrow, and I expect that that's a statement that I'm making and it's a promise that's behind that, it might not be as weak. It might be something that we, in fact, can depend upon. And so there are ethnic and cultural differences. There are more of these than you might think, and we got to keep an eye on some of those as we go along here. Finally, there's an interesting study about whether there are gender differences in the ways that folks negotiate. And in fact, some have argued that, well, women are from Venus and men are from Mars, and there's more of an adversarial approach in negotiations that men take, and women are much more looking at the relationship and trying to support the relationship. And there's some studies and some support for that. It turns out, though, that good negotiators, I would argue to you, need to have both adversarial styles at times and be able to use bluff and bluster, and that, in fact, you need to be conciliatory and think about the relationships and the relationship effects. And those are not gender-specific differences. Still, there's a good literature out there about how women and men might differ in the way that they negotiate. And it's interesting to have you place yourself in that setting. Now, the other thing is, we've already mentioned this before in game theory. Game theory explores the difference between rational behavior and other non-rational features that affect the way that people see a particular dispute, whether or not it's an issue of identity, whether it's a matter of principle, whether or not what's going on is governed by a biasing impact based upon an inability to put aside your own feelings sufficiently to be able to be objective about what's going on. And so we're going to draw on social psychology, and I'll explain that to you in a little bit. But the idea is that there's plenty of theory, and what I'm going to try to do then in our brief time together is to try to merge all of this literature into two basic different ways of looking at negotiations. And in looking at the negotiations, I'm going to divide in, and I think it's important for you to divide in your mind, whether a transactional lawyer or a litigator, that you divide in your mind the differences between being what's called an adversarial bargainer, or otherwise referred to in the international literature as a position bargainer, versus a problem-solving bargainer, or somebody who is interested in not positions but interests, what the interests of the parties and the underlying needs are, and how it is that you can address those interests and underlying needs. So those are the two basic differences that you see in the literature as to the different approaches, and I will ask you at the end to try to think about ways to merge these two into a comprehensive way of preparing for negotiation so that you can get the maximum amount of control out of the negotiation. So let's talk about what those differences are. So first of all, as you can see, an adversarial negotiation is often thought of as the way that people who are in litigation will approach a negotiation. Adversarial bargainers are thinking about, well, what's the value of this lawsuit between Hewitt and Gonzalez? And then what we will do is we will take positions then, and in taking those positions, we will try to figure out whether there is any overlap between the positions that we're taking, and if there is an overlap, then we'll be able to settle this case. The positions we take are substitutes really for an in-depth understanding of what the other side is doing. In a sense, the position is a bluff that I take and I watch and I see what your reaction is, and then I judge from the reaction whether or not, in fact, there might be some way to agree. And this is the kind of bargaining, otherwise referred to as zero-sum bargaining, that we commonly think of when we think of bargaining in the marketplace. Don't be too quick, you transactional lawyers, to say, well, I'm a problem solver. Our instincts are overwhelmingly that what we do is we look at the value of something and make offers to buy it. And there are counteroffers that are made as a substitute really for understanding what people's real costs are that they have in the product, what their needs are, what their interests are, what they're trying to do in making the product. Really what we do is, like a used car salesman, we take a series of offers back and forth to find out where their bottom line is likely to be. So that's the problems, the adversarial style of negotiation in a nutshell. And the problem solver, you can see, on the other hand, thinks about the problem as not being a zero-sum game. In fact, it sees the problem as having a number of underlying needs and goals, possibly win-win solutions that could be brought about. Think about how transformative it is to say to yourself, in the Hewitt versus Gonzalez negotiation, are there any business solutions the parties might want to consider? This is a question you are going to be asked by your mediator in the next week when you look at a mediation of this dispute. And the mediator is asking you, in a sense, should we explore any win-win solutions where people might be able to come away and both win? Are the parties interested in reestablishing a business relationship of some sort and expanding out that partnership once again to take advantage of what is the value in that mine down there in Mexico? Or are the parties looking at this as a one-time adversarial negotiation where they're hoping to never see each other again? So problem solvers are interested in, and it's why it is the language very often of international negotiations where parties see themselves as living as neighbors, see themselves as living maybe within one community and having to then get along. And in problem solving that relationship over a period of time, that what they're looking for are solutions where they can both win as opposed to only one winning. And that's at the heart of a problem solving approach to a negotiation. So think about this in a kind of a classic situation where you're going in to negotiate, let's say, with me as your employer for a law firm. You go in and you look at it, and what you do if you're an adversarial bargainer is you go in and you have in your mind what you believe are the various offers that you're going to make on a continuum. And so if we look at it here, it's clear way down here you'd like to get paid $165,000. That's what you hear New York associates are making. And it might be that you're tempted to have an opening offer. You know, the environment has changed. Maybe what you'll sell for on the outside is $150,000. At the same time, you've talked to your friends around and you've heard that there is some uncertainty in the marketplace, and so you say your opening offer to me is I'll work for you for $150,000. And the response you expect is no, that we're not New York. But you've done your research, and the second position that you're going to take as a target point might be $135,000. That's what you've heard that associates have made at that particular law firm in the past. Now, with all the uncertainty in the marketplace and all of the dynamics of that, you're not sure how your particular firm is going to react to that. And so it might be that you've looked at all your finances and your paybacks of your loans and you've decided, I really want to stand very firm on $115,000. I'd like to get $115,000. I think that that's something that is a commitment point or a CP for you. And in the language of adversarial bargainers, it might be your spouse has a job or your significant other has a job in Atlanta, which would actually make you even go below the $115,000, maybe down to $105,000 for the purposes then of being able to be in Atlanta and work. I, as the law firm on the top of this, might say, you know, I think now with the economics of the law firm changing, my thought is that you ought to be fine with $80,000. That's an average salary for an average associate in a law firm. I'll pay you the average, $80,000. My commitment point might be $100,000. It could be I see a family connection with you that would take me to $115,000, or it might be that I'm getting some pressure both because of your family connections and because of your special expertise that you bring, that in fact I'm willing to go all the way to $130,000 for you in a one-time deal. Well, you can see that what happens then is that you can think about this as a zero-sum game where we're looking within our settlement zones where there is overlap, where we have overlap. The bottom line of $130,000 for the firm, the bottom line of $105,000 sets up then a zero-sum game. And if we're thinking about it, every dollar out of one person's pocket is a dollar that they don't need to give here if they really could figure out what your bottom line is. You can see that an adversarial approach then substitutes offers for real understandings of the information to try to check and figure out where somebody is going to be. And so if I'm standing in the marketplace and somebody is offering to sell me something, that what we might do is to say, I see the sticker as this, but I understand that in your culture I should discount that 15%, so my first offer is, you want $100, my first offer is $85. And then the person says no. And then I say, well, how about 70? And they might say no. Or they might say, well, if you buy 2 of them for 70, that'll be fine. And what we do is we take positions back and forth in order to be able to test where the other side's bottom line is, what it is that their true costs are. Right? So, as opposed to problem solving. Now, problem solving imagines that the parties instead are interested in also thinking about whether there's a relationship interest between the two that can be the foundation for win-win solutions. To do that, what we need is information about whether people have that. They have to change or transform their thinking in some ways to look at their underlying needs and goals broader than just the exchange on the marketplace on that one day at that one time. What's helpful here is to think about what are the needs the parties have. What of them are shared, what of them are independent, and what needs are conflicting. And by looking at those needs in this way, we may be able to use shared needs and independent needs as ways of overcoming needs that are in conflict. A classic example of this is something that is, let me just say, is brought about by thinking about an orange for a second. And in the materials and the reading, you can read about this some more. Well, what do you mean an orange? Well, we both walk into a grocery store, and there is an orange that's sitting in the bin. And both of us come at that orange, and it's one orange that's left, and the sign says 25 cents. If we both reach for that orange at exactly the same time, in exactly the same way, and we have exactly the same amount of strength, as we grab that orange, the question is, how do we divide the orange? Well, matters of strength, matters of wanting it more, bribes come into play. There are all kinds of ways that we may still be able to resolve this between the two of us, but basically it's about who gets the orange. If we do a little information gathering and we find that one of the parties needs the orange for a garnish for a drink, and one of the parties needs the juice for a cake that they're making, then what we can see is that there are win-win solutions. We might be able to cut the orange, we might be able to slice off a slice for the garnish, and then give the other person the rest of the orange and have them have the juice. If we ask, why do you need the orange? And this is transformative. I can't carry it to you enough about how it can be transformative. Why do you need X number of dollars? What are you looking for in this negotiation? Why? What are your underlying needs and goals? We may be able to get at some of these conflicting information, sure, but also it might produce some shared needs, or it might be that we have independent needs that we can each meet without doing damage to the underlying orange in order to be able to get our needs fulfilled. And in the notion that the orange could be a substitute for Jerusalem, you can start to see some of the power of the idea. If Jerusalem is all about who gets Jerusalem, there's not very much we can say about it other than to fight over it. If each side has religious views that they're entitled to it, that they should own it, then in fact it's going to be very hard for us. Their identities are so tied to the ownership of Jerusalem that it's hard to see how we can negotiate out from under it. But if we look at shared needs, what are the shared needs the parties might have? Might it be that they both share a need for ability to worship in their sacred places and secure areas, and that they need security to be able to do it, and they need a place to be able to grow, and they need a place to be able to be educated according to their religion, and they need a place to honor their history and a place to come to. And to the extent then that the old wall of the temple is a different place than where the Dome of the Rock is, it's a possibility then that we may have some shared needs and independent needs that potentially could be managed by creative solutions that help us get to the problem. So we might even look at Old Jerusalem and entering from different gates and in different sections, and what those entrances, those different entrances look like to give people the feeling of ownership and sovereignty, and at the same time provide for a sharing of the space in ways that both meet the needs of the individual parties and potentially also meet the security needs that individuals have. And the potentials are that we might be able to, if we think about Jerusalem like an orange, be able to overcome the conflict that we've got. Now, having then stated what are two basic, what we're calling strategy approaches, problem solving as a strategy and adversarial bargaining as a strategy, we have to stop here just a second and distinguish between adversarial and problem solving in the way of strategy and something that's called style. And let me give you a couple quick examples about what I mean by style differences. First, if you think about it, if I come to you in a used car dealer way, and you're the used car dealer, and I'm a person who's trying to negotiate for a used car, I might come up to you and I might have, for example, a black t-shirt on that says in white letters, "That's Mr. Asshole to you." I could use profanity on the t-shirt as a way of getting your attention that I am a real adversarial bargainer. And I could come into you and I could say to you, "Look, I hate you people. I can't stand your guts. What I want to do is spend as little time with you as I possibly can." In that setting then, I am as adversarial in my tone or style as I possibly could be. But I might then go on and say, "Look, because I want to spend so little time with you, here's the deal I'm willing to make. You prove to me what the costs are that you have in this car. You prove to me that. And you do it in 15 minutes, and I will pay you $500 over those costs for your time. $500 for 15 minutes. What I have done is I've tried to identify a few underlying needs and goals and put those out there as the foundation for doing business. Isn't that fair for you? $500 in 15 minutes, but you prove to me what your underlying costs are. In that instance, my style is adversarial, competitive, in your face. My strategy is actually a bit of a problem solver. I'm trying to get at your underlying needs and goals and then to satisfy those needs and goals. Or let me flip it for just a second. Imagine, if you would, a wonderful, warm grandmother who you're visiting and you're coming over to see, and you're a small child and you're trying to negotiate with your grandmother to stay up and watch TV some more. You say, "Grandma, I want to stay up and watch TV some more. Can I do that? My mom lets me do that. I can sleep in tomorrow, it'll be okay." Well, grandmother could say, "Come here, honey, give me a hug. Give me some sugar. Let's kiss," and says, "No. No, I'm sorry. It's time for bed." And what you have in that situation then is a style that is very warm and friendly. But that what you have is a strategy which is position bargaining. No explanation, no exploring of underlying needs and goals, just simply a position no. And folks, if you want to see a difference between the South and the North and the old style of Southern negotiation, what you have is, in the North, you make a demand and the person says, "Are you crazy? Out of your mind?" In the South, you shake your head and smile. "No, we can't do that." And what that is simply a style that is friendly, but it's a strategy that is position bargaining. "No, I'm sorry, we don't do that here." So distinguishing between style and strategy is important so that you don't get hoodwinked into thinking, "Oh, I'm with a problem solver," when in fact their strategy is different than that. And to explore that, there is a way of looking at negotiations and watching people negotiate. Game theorists do this, and they categorize people according to their strategies, adversarial versus problem solving. They measure that by the words that they're using and by their styles. And what they come up with is they come up with some attributes depending upon what style and strategy combination they're seeing. What they notice is that if you're a competitive style negotiator, if you're a black t-shirt guy and you're very adversarial in your strategy, then it's likely that you're going to be rigid and you're going to be risky, and the risk is you're not going to make a deal. But the deals you make, you might do very well in. You're going to miss many more deals because you're arrogant and offensive and it's going to cut people off, but on the individual deal where you're successful, it may be that you're very successful. And it's a way we think very often of plaintiffs' personal injury lawyers. They come in, they make a very high demand, and they stay with that demand come hell or high water. And that the argument is that they become in some ways over-married to their client's position in the lawsuit, and it's risky, it's rigid, but at the same time, it can be very effective. If you're a problem solver and you're using a competitive style, if you're a problem solver, you're on the other end of the spectrum. But similarly, you've got a limited needs and solutions piece. And that is, you're like our black t-shirt guy. You've got limited needs and solutions that you're willing to look at, but you're taking a competitive style with it. And what that does is sometimes it forecloses problem-solving solutions that might be available to the parties, but you set some structure on it, and it's a combination then that has some benefits and some downsides that the more adversarial strategy has. If you're cooperative and you're an adversarial, you appear to be willing to make concessions and compromise. That can lead to continued conversations between the parties, and that can have some real benefits to it. But if what you are is cooperative in your style, but adversarial in your strategy, you can see also that the no doesn't leave you too much to talk about. Not too much, not too extensive, and it can create some real problems. Here's the problem also, to really look at this one. A cooperative style and an adversarial strategy. This is brought home to me by an experience I had a number of years ago training black South African business people in negotiation strategies. A black South African who was in management, who was identified by USAID to come to the United States for some negotiation training, came up to me and said, "Boy, I'm glad to be in this program. Teach me how to negotiate like you Westerners do." And what he was looking at was a way to deal with what he had experienced, he and his family had experienced personally with a business that they had. And here's the story he told me. He said, "I sat down with a Western European businessman who was come down right after apartheid was over, and he made the following pitch to me. He said, 'Look, I'm here to try to help you succeed. I want your business to grow, and we're here to see if South Africa can be really the economic engine that can help for all of Africa. So tell me about your business, and we're trying to be helpful. Can we help?'" He was then cooperative in his style. What the young South African man said to me is, so I told him about our business, our supply problems, what we were having problems with our distributions, what kinds of markets we were having difficulty getting into, and how we were getting name recognition. And the Western European went away for a period of time and then came back. And when he came back, he set up a competitive business. He had no intent at all to reach an agreement. He was just there for information. So this is tough stuff. If you are cooperative in style but adversarial in strategy, you are not bargaining in good faith. And there's nothing that automatically tells you whether or not a person who is cooperative in style is really open to all needs and solutions and is problem solving in strategy, or is really just there to take advantage of you and maximum advantage of you as to the information that you're giving. And that is why it's important to realize that if you start to do problem solving that involves giving information that is crucial to your business, out of a trust that you have for the other side, you run some real risks. And the risks are that what you run is that the adversarial strategist is not there in good faith, is gathering information. You see this all the time when you hear about people who refuse to go to mediations because they don't want to just give away information to the other side. They don't believe the other side is there in good faith. They refuse to go and negotiate because, in fact, you don't have authority to settle, so all you're doing is you're just talking with me to getting information about my lawsuit. It's why many lawyers will say, no matter how cooperative the person is, do you have authority to settle today? Because otherwise, we're wasting our time. And so, part of the danger of a cooperative style and an adversarial strategy to a problem solver who is cooperative in style and is also problem solving in strategy is to know whether the person really is acting in good faith or not. Well, if you're both problem solving in strategy and you're cooperative in style, and both parties are there in good faith, then under the style of Fisher and Urey and the Harvard Negotiation Project, you're getting to yes. What you're doing is now you're exploring all the needs and solutions, and you're looking for win-win solutions to overcome the deadlock. The problem is that these negotiations, to get all the needs and goals in on the table, are longer, they're more complex, they create complexity as they include more and more needs into the picture. As soon as the adversarial bargainer says, how about if you take 2 shirts? How about if you take 3 shirts? How about if I get a bonus if I sell all my inventory and I'll split the bonus with you? What we have is now complexity that starts to get into the picture that takes time, that sometime that people are just not willing to tolerate. Now, when you think about what goes on, for example, between 2 business people in China trying to do business in China, say Coca-Cola in China, where you do not have a rigorous law society where you can run to a court to sort out what the contract was that the 2 of you entered into. What you're left with is, in some ways, the quintessential problem-solving strategies and cooperative styles. You're trying to set up a system where you start to learn and trust each other to be able to do business that's not based on threats or positions or being able to go to court. What you're trying to do is, in some ways, take the law out of it and just simply say, in learning about you and learning about your needs and your goals, what can I do in order to be able to decide that our interests are aligned sufficiently that we should go into business with each other? The Japanese have a name for it called the wa. They say, what we're going to do is we're going to exchange business cards. We're first going to do nothing more than have dinner together. We're going to bring all of our parties together at different levels of the organization so we can get to know each other. And as a substitute for a quick negotiation between the heads where we form a contract, what we're going to do is we're going to take a much more expansive approach and find the wa, to find out whether it's right to get together. And in business terms then, for a Westerner, this may seem very inefficient. There may be an unwillingness to actually play the game by those rules. What I'm looking for instead is an international arbitrator who can sort out the dispute. I'm not going to the Chinese courts to enforce my contracts. I'm going to have an international arbitrator sort out what the contract means. In those kinds of situations, our negotiations then are going to be more adversarial, based upon meaning being put into the contract that we're negotiating. If the Chinese business person says, sorry, I don't do business with international arbitrators. We do business here. If you've got a problem, you can use the Chinese system. You can see that you're left, if you're a Coca-Cola, with trying to reach an understanding of that business that's sufficient to give you enough of an insight into their needs and goals to be able to figure out the trust. So these ideas in negotiation are very powerful. And they're powerful because they create solutions. Problem solvers with cooperative styles create solutions, but the trades are with efficiency and certainty and the ability to get a quicker resolution of the problem. And that is basically the dilemma of moving into a problem-solving environment, especially when your expectations of your adversaries might be adversarial and competitive. Now, from social psychology, we know that a great many of us, though we may think of ourselves as problem solvers, are actually cooperative adversarials most often. And what we are then is that when our instincts are that when we are pushed, it's a zero-sum game and we're trying to get the maximum for our clients. There is even an argument that as a lawyer, that's what the law demands of us, that we act as adversarials on behalf of our client, and that we cannot be cooperative just simply for the sake of the relationship, certainly without a lot of permission having been given by the client to do it. And so we'll explore this. We'll explore it a little bit by asking you, has your client given you permission in Hewitt versus Gonzalez to explore problem-solving, win-win solutions, business solutions to the problem? And if they have, then obviously you're freed up to do it. If you haven't, it may be that you don't have the authority to negotiate as a problem solver, that you must, in fact, continue to act as an adversarial in a fundamental way to try to get the maximum deal for you in this litigation. So, here's a little mantra. Remember that orange example that I've given you. When you hit deadlock, one thing to do is to remember the orange. If you don't want to walk away and litigate the case, you want to try to see if there are problem-solving solutions and win-win solutions, then, as opposed to positions, ask about underlying needs and goals. It's an international problem-solving method that builds on a process of trust, looking for shared needs and goals, and it's during the trusting process that you build that trust in negotiating and listening and thinking about how it is that you both might win, that potentially you get to problem-solving solutions that are win-win and are creative. And I urge you all, as you're thinking about it, the expectations of the marketplace are that you act adversarially. If you still want to hang in there past that adversarial position bargaining, it might be that you try, remembering the orange, to go to underlying needs and goals. Now, if we had time, what we would do would be to play a dollar auction. And a dollar auction is a way of getting you to think about how it is that there is a really strong economic force that exists in many disputes. And the economic force has to do with the psychology of sunk costs. And let me just give you a couple examples. The dollar auction makes it. Let's imagine that I have $1 in my pocket, and that what you are is you're going to bid for this dollar, and your first bid has got to be greater than 50 cents. And let's say that the rules of this auction are that you have to bid in at least nickel increments. So no pennies. It's got to be nickels, dimes, and quarters. What this means is that your first bid is going to have to be 55 cents or more. Second, or third, last, that in this dollar auction, you will owe me your last bid. You will owe me your last bid. Now you might say, okay, I'm going to do this. I'll bid 55 cents. And somebody else might say, well, I think I can get $1 for $1. I might go to 95 cents and go in and say, I'll have 95 cents, I'll get the $1, and then I owe the 95 cents and I'm good. You might start to bid without thinking about what this last bullet means. And so you might say 95 cents. You call it out. You bid. Now what does that do then? Well, now you're in the game. You're playing. And if you don't get the $1, it means you lose your 95 cents. That's the same for the person that bid 55 cents. The 55-cent person says, oh, wait a minute. If I bid $1, I get the $1, I'm out the 55 cents, and I'm still 45 cents ahead. So the person says, I'll bid $1. The 95-cent person says, I'll bid $1.05. 55 person says, I'll bid $1.10. And then the parties look at each other and they say, uh-oh, wait a minute. What we're doing is each one of our bids now makes it such that we will lose that if we don't win, which incentivizes us to keep bidding. And when I run a dollar auction in workshops across the country, it is not uncommon for me to go $6, $8, $9, $10, $15 before people stop bidding. And of course what has happened is that they have lost sight of the underlying value of the dollar, what it is that they're bidding for. Why? And that's what's so important to look at. And you see in litigation, part of what people do is that they're paying you as a lawyer for the litigation costs. Those are sunk costs to them. As they pay your bill, especially as a defendant pays the bill, those are costs that then they're losing. And if they don't win it back by winning something in their counterclaim, then what they are is they are out. They're out that sunk costs. And psychologically, they can then start to see that they are paying net more than what the underlying litigation is worth because they're unwilling to have wasted, they see, the money that they've already sunk into the situation. Now, what game theorists say is that that's not acting rationally. Once the decision has been made to spend the 95 cents, that money is gone. And it shouldn't come into play in deciding whether I'm going to go to $1.05 or $1.10 when I'm asking what it is that I'm getting. But you can say that many times, and it's very hard to convince yourself of that psychologically. And that's why it's important to realize that psychological costs, sunk costs, can make people pay a lot more than what they would otherwise do. The reverse of sunk costs is when they've sunk costs into something, into some time that they spent with you, then what happens is that they then are willing to sink more costs into it to get you finally to go ahead and buy the item. Let me demonstrate that, the reverse of the sunk cost problem. If you're negotiating with a used car dealer and you've made a bid and the person says, give me a bid, just give me a bid. And you give them a bid on a car, let's say it's $24,000, and you take it back to the management. And as you're sitting there, you start to think about all the time that you spent leading up to making that bid. You drove the car, you spent time looking at it, you did some comparison shopping, and now you're sitting waiting for the car dealer to come back. And who knows what they're doing back there, but the time is ticking, it's going, it's 20 minutes, 30 minutes, he's still not back. And the whole time you're sitting there, you're thinking, if I don't do a deal, well, I'll have to go through this all over again next time. My costs are my time, and I'm sinking those costs the more time that I'm making. And the used car dealer is in fact betting that that's what you're doing. That the more time you're there and the more you're imagining yourself driving that car, the more that you have sunk your costs into having that deal go forward. And when they come back and deny your offer, what they do is they can bet that the psychology of the sunk cost means that you're going to add to your bid. You're going to up your bid. At least that is what they're betting on. And so, sunk costs then can be a powerful force in a negotiation that can really affect the rationality of people's moves and the moves that they're making in getting an item. It can make them pay more than $1 for $1. It can, once they've already invested in it, it can make them spend even more money to try to get more of what it is that they wanted at the hopes that the money that's already been spent has not been wasted. Now, a couple other things to notice here when you talk about this dollar auction. You might bid, and as soon as you bid over $1.05, you feel tricked because you didn't really understand that last rule. And so you cross your arms and you say, I don't trust you anymore, I'm not moving. And no matter how much I cajole you, the audience that's sitting around chuckling at you for having offered more than $1 for $1 is making you resist. And we know this is an enormous factor in any kind of game theory and negotiations. It's the audience effect that makes a person more intransigent. You can see this whether it's a president that's coming in to negotiate on behalf of a citizenship about their willingness to make concessions. I can't make the concession. My constituency will think that I'm weak. My audience will think that I'm stupid. My audience will think that I don't care enough about them. The audience effect on a negotiation is a psychological force that makes people less willing to move. To overcome this, then, a lot of strategies are involved. We could overcome this by negotiating in a situation that doesn't look like we're negotiating. We could just be talking. Or maybe the court has ordered us to mediate, and so I have to do this. It's not that I want to do it, but that I have to do it. I can buy some cover then by developing a strategy where I don't show myself disloyal to my client by being willing to talk about concessions. We might, in an international setting, hold a conference where people are talking in what's called back channel ways, so that there isn't any risk of the public hearing about it or learning about it and then acting in a political way to keep the negotiations from going forward. And so, in some ways, you can think that's at the heart of what the Carter Center does, is that it finds ways of getting people together that aren't looking like negotiations. They might bring people together about fighting the guinea worm, or might get them to come together about some health problem, or some disease problem, or environmental problem that both sides could work on together, hoping that in and or out of the glare of the formal negotiation, that people get to learn to trust each other and are more open then to making concessions and finding creative solutions. These are then psychological forces that you have to be aware of. If during a negotiation a person feels like they've lost face, if you negotiate with the North Koreans and they feel like you've disrespected them, then the negotiations are over. If there isn't some way or willingness for a person to save face, what you're doing is you're creating a psychological force that may not be rational, but it's just going to be flat out a personal reason why the negotiation doesn't go. So lording it over somebody, playing your power card too strongly, not giving people a room to save face and to compromise is going to be very important for successful negotiation. All right, so we spent a lot of time then with negotiation in terms of style and strategy, but it's that language that is really important to see what it is that you might need to do in order to prepare. And basically, my suggestion to you is that there are 3 stages to any negotiation. The first is an assessment stage, the second is a persuasion stage, and the third, to be a negotiation, we're going to expect that there's going to be some exchange that's going on. Now, we're going to spend the remainder of our time on this assessment stage, and that is because a great deal of the results that you get in a negotiation have to do with how well you are able to get information from the other side about what their positions are and about their willingness to do creative solutions. And so what we need to do is to think about ways and styles and strategies for getting information that will help you assess what the other side's true bottom line is or what their true wishes are about their willingness to create solutions. There are key questions then in your interviews during the negotiation that are looking for meaning, trustworthiness, and helping you with your valuation. The control of the critical information correlates to your success. That's what all of the game theorists tell us. Your ability to hold your vulnerable information close to you without revealing then that vulnerable information, but get information from the other side increases your chances of getting a successful negotiation from your side's perspective. Recognize that already assumes a certain model, an adversarial model of the negotiation. The better you are able then to protect and get is what the negotiation of information seems to be all about. Negotiation information can start a long time ahead of the negotiation, finding out about both the negotiating styles and strategies of the opponent, finding out about the negotiator, about what human situations they find themselves in and pressures they find themselves in. A used car dealer who needs to make a certain number of sales or clear the inventory out is going to be more vulnerable to negotiation than somebody that is selling cars like hotcakes and just doesn't have any real stress to sell you a particular car. So historical facts about the negotiator, about the particular client in the real world. You'd go on the internet and do a discovery to find out about the business you're negotiating against. You'd look in Google, you'd look to find out about the CEO or the person who's controlling the negotiation. You'd find out about them personally. You find about their 10Ks, the quarterly reports to the SEC, what their projections are as to what their profits are going to look like. These would be all questions of information that you'd get to help you in the negotiation. And to control the negotiation during the negotiation itself, the lawyer must be able to get, give, and guard their critical information. You can't do this on the fly. This has got to be something that you look at systematically as a preparation before you go into a negotiation. What I would do then is to say to you, use charts if you're a chart kind of a person. What's the information that I need to get from the other side? What is the information that I need to hold or protect? And what is the information that I'm willing to give to the other side? And think quite systematically about it. If you do not do that, you are going to get caught when an opponent asks you a question about your vulnerabilities. Imagine yourself in the Hewitt versus Gonzalez negotiation. Imagine that, in fact, what you've looked at your situation and you've decided, look, I really do feel a little guilty about what it is that I said, but Hewitt feels like he feels guilty about that, and he's willing to share some of those proceeds that then he got in the buyout. He's willing to give 30% of those proceeds back. So let's say he's willing to give $600,000 back to settle the case. And so your opponent says to you, Mr. Hewitt, what's he willing to settle the case for? Then you say, no, he's not willing to settle the case for anything. And the question then would be, is that if you were not ready for that question, you might stumble and stagger a little bit around it. Well, you know, he's willing to come up with, you know, something to settle the case today. And you would leak if you hadn't been prepared. All right, I've got to protect my client's bottom line. What am I going to do? What am I going to say if a direct question is asked? How much is Mr. Hewitt willing to pay? If I haven't prepared for that, I'm likely to be leaking the information. There's other information like, is there any interest that Mr. Hewitt has in some kind of a business solution going forward? Well, if you're willing to give that up, put that on the table, you've prepared for that, you've gotten the permission of Hewitt, then you might be able to say, yes, I think we'd be willing to think about some kind of a deal if it could be something in the U.S. that will help bring the parties back into a good relationship. Then you'd be ready and you'd be willing to go ahead and give it. And from your side, you would want to be able to say, well, how about what is Gonzalez's thinking about that? Has he decided? And I'm going to need a trade. He'd be willing to, if in fact Gonzalez is willing to. And by classifying your information then in these three forms, you start to prepare for what it is that you're going to get, what you're going to give, and what it is that you're going to protect. Now, really quickly, something to tell you about moral intuition and settlement. It's important to realize that the conflict resolvers tell us what we are doing is we are assessing in classic litigation the type of dispute that we're dealing with. If what we have is a character flaw, if what we really have here is that Hewitt is a racist, he is said some things that are racist and intentionally and maliciously designed to hurt Gonzalez, we have a character flaw. And what we need is apology and punishment at a bare minimum. And the punishment's going to have to be at least compensation and plus punitive damages. That's a human intuition if those are the true facts. If what we have is a kind of a recklessness, a negligence, then we're going to need compensation and maybe something a little bit more. If the neglect is what you could call inadvertent neglect, it really was not even reckless. It was just a throwaway. It was an attempt to be maybe funny. Then compensation of some sort for whatever harm was caused, and that's going to be difficult in this case to decide what is the harm that was really caused, is probably all that a jury typically is going to provide. If it is an accident, an honest mistake, then its potential is that it may go away with just simply an apology. And those then are what the parties are trying to figure out what a jury is likely going to do. And the negotiation then can be seen as in some ways an information exchange to find out where are we. Is this a character flaw? Is this reckless conduct? Is it inadvertent? Is it an accident? And the parties then are not only exchanging information to find out how each of them perceives it, that can be done in the way of persuasive statements up front, but they're also trying to see whether they can bring the other party to believe that in fact their categorization is true, and what the reactions are going to be, what the proof is going to be, what the evidence will actually show about whether or not we're in one of the categories or another one of the categories. So information is really crucial. Getting information in negotiation, and it's important to remember how it is that you get information. There really are three different kinds of questions that you ask. They're the same kinds of questions you ask in the courtroom. There are open-ended questions. What are you looking for in the negotiation? Why do you want that? What are you trying to achieve in the negotiation? There are open-ended questions. Tell me about how you see the lawsuit. Those are open-ended questions that get the person to talk. Now, the problem is that in a negotiation, many of us are worried that if we open ourselves up with those kinds of questions, we may in fact be persuaded. Now that's a risk, but it's a risk worth taking. The more the other person is talking, the more you have information and the more you are still concealing what your vulnerabilities are. All you're getting is how they see it. You are not necessarily communicating that you agree. So open-ended questions are a style of questions that I would recommend that you use in a negotiation to get the other person to talk. the risk is a small one. The possibility that you're misunderstood as agreeing with the person is saying. Otherwise, the open-ended question is a way to get unedited responses to key areas of questioning. A more targeted question is a question that starts with did you? Did you? Were you? Are you ready? Do you have authority? Can you go higher? These are questions that start with verbs. There are narrower, they're more question and answer. Do you agree with what I've just said? They don't get nearly as much information. They risk then that in the need to control, that what you're doing is also revealing what's important to you. And so narrower questions are important to pin people down. They're important to get precision, but they also risk cutting off the information that you might otherwise get. Leading questions, though, are great ways to summarize what it is that you've heard. And so a leading question, so it sounds to me like what you're saying is that these are the demands that Mr. Gonzalez has. That by summing those up and with an agreement of yes, then what you have is you're confirming. And those are your fundamentally three different ways of gathering information. So, armed with then those kinds of questions, what you want to do is think strategically. What are the likely vulnerabilities of my other side that if I ask these questions, I'm hoping to get information about in order to be able to maximize my chances of getting that information and getting a good result. If you think in terms of the information you need, it's likely you'll also think about the information they need from you. And in that way, then, we have to be careful about a final point here, which is about ethics. And that is, what are the ethical constraints to your lying in a negotiation? It's important to realize that when you're getting information, that if you pay attention to the person and you active listen, you can get them to do a lot of talking. But when you go into active listening follow-up questions, this is a place where you have to sort out what is the obligation of the other side to answer my questions. Now, there are obviously three possibilities. One is that the person honestly answers your question and that you honestly answer the question because you've decided ahead of time this is something you're free to give. Another possibility is that what you do is you misrepresent. And the short answer is that if you make a false statement on behalf of a client, you're committing fraud. That's the short answer. The question then is, what is a statement? What is a false statement? And what does it mean to make a false statement? So, when you answer a question, the third option is something to consider and prepare for. And that is, what should be my blocking technique? And I would suggest to you that there are a number of blocks that you should be facile in giving. The first is that you don't answer the question that's asked, that you answer the question by asking another question. That's an interesting question, but I've got one for you. And you push back. What is Mr. Hewitt willing to do in terms of ponying up some money, some real dollars? Well, let me ask you. What is Gonzalez interested in doing in order to be able to settle this lawsuit? How much does he feel like he needs? And you answer a question for a question. Or you over-answer the question. What you do here, and this is a really important strategy, it's one that's very effective. Look, we're asking for fairness here. We're looking for justice. We don't want to pay a dime more than what the law requires us to pay. And that's what we're here about. You over-answer the question that's been asked you as a way of blocking specific information. Ronald Reagan was a pro at this. Are we going to send troops to Afghanistan? We will do whatever it takes. We'll climb any mountain, ford any stream to make sure that liberty rings from shore to shining shore. And we will do what is in the America's interests and will not be constrained by anybody. Well, such a statement is an over-answering of the question that doesn't say whether you're going to send troops to Afghanistan. Over-answering the question then is a blocking style that requires the person to name it, name the block, and pass back through it. That's well and good, President Reagan, but my question is more specific. Is sending troops to Afghanistan on the table? Is it an option? It bets on the social graces making a person not be willing to do that. In a negotiation, if you get blocked, one of your options is to see it as a block, but then also to name it and push through it. Now, another way to deal with the question that's asked is to answer a slightly different question than the one that's been posed. If you're asking me whether now, in the light of what we know about this case, I would recommend that Mr. Hewitt settle this case, no. I don't think we have enough information to be able to do that. That's a different question then. The question of what is the amount of money that he's willing to pony up. It's a slightly different question. It answers the question that you posed, that you reframed the question. All right? And that's a block. And the final block is that you just ignore the question and keep talking on the subject that you've been talking on. Well, let me get to that. But first, we've got to sort out this. It's an agenda control move. What you do is to say, you know, down the road we'll talk about that. But right now, let's stay on how it is that we value this case. And these blocks, then, can be prepared and should be prepared as a way of managing the most important part of the negotiation. That is the information exchange. What you get, what you give, and then what you hold close. We'll come back a little later and talk about what the ethics rules themselves say and what leeway there is here for being able to make a representation about a person's intentions with regard to settlement. So we'll come back, we'll visit that. If you get the information right, then there's still plenty to learn about concessions and concession exchanges and concession patterns, about persuasion. Of course, we're working on that as a group for the rest of this semester as to how you persuade. Part of your negotiations will be then to try to persuade your adversary about what you think the value of the case is. You will do that in the light of something that's called BATNA. What is your best alternative to a negotiated agreement is done in relationship to what you think the trial will look like. And what your percentage chances of winning and losing at trial will then be part of the persuasion in the negotiations. And you should prepare that, obviously, also in a very careful way. Recognize the style of those presentations is meant to be one which the opponent can hear it and to respond to it. And it's not going to be off-putted because you're arrogant or you're demanding or you're talking in a tone that makes them resist it for other reasons. Your persuasion then should be as prepared as what it would be for an opening statement in front of a jury, and then should be bridged into percentages that help the other side understand that there's some room, there's some probability analysis that's going on, and there's plenty more to learn there. So this is a window into a whole course on negotiation. It gives you some of the basic concepts, problem solving versus adversarial bargaining, and how to talk the language of a problem solver with needs and goals as opposed to position bargaining of the adversarial. And gives you some ways to think about informations and risk and information exchanges to help you get ready for your negotiation. Thank you.